Jefferson County. But then another part of it is, if we have a concern, what's the alternative? Because then if we might get into a situation under the law where I'm supposed to weigh the pros and the cons. Ma'am,
look at me,
ma'am.
He keeps turning around.
Ma'am, I told you once before. Let me please help you understand. You're smiling. I don't know why you're smiling.
Because I can't.
Well,
Because I can't. It's not a crime to smell.
it's not a crime. to
Continue
smile,
what you were saying.
but it doesn't help you, all right, to irritate people.
All right.
And you have a lot of
She had been sitting in that courtroom for 7 years, a grandmother, waiting for answers that took longer to arrive than anyone should have to wait. And the man sitting across that room, the man at the center of all of it, turned and looked directly at her and smiled, not out of nervousness, not by accident. He smiled because he wanted her to feel it. The judge noticed. She said something directly to him about it. His response stopped the entire room. He told the judge, and everyone else listening, that smiling was not a crime, that he could do whatever he wanted. That smile would follow him all the way to a prison cell he will never leave. But before we get there, there's another courtroom. 2 15-year-olds, a stolen car, a high-speed chase across 4 cities, and a judge who had seen enough. Both cases. 2 different courtrooms. One outcome that neither side saw coming. Stay with me, because this is where it gets real. Welcome to Redacted Files, the channel that covers the cases. The headlines move past too quickly, told with the facts, the details, and the full story. If you are new here, subscribe right now. Today, we are covering 2 real cases involving real teenagers, as both the ones who made the wrong choices and the ones who paid the price for someone else's. There is also a development in one of these cases from just weeks ago that most channels covering this story have not reported yet. You will want to stay until the end. Drop in the comments where you are watching from right now. Our community watches from all over, and I want to see exactly where you are tuning in. Now, let's get into it, because the first case starts on a leap day, and nothing about it goes the way it should have. February 29th, 2016. Lighthouse Point, Florida. A patrol officer spotted a stolen Hyundai Sonata moving through traffic. Standard procedure. Pull the vehicle over, run the plates, handle the stop. It should have taken 10 minutes. Instead, it triggered one of the most reckless pursuits Broward County had seen in years. The moment that officer moved to initiate the stop, the driver refused. 15-year-old Maurice Thomas pressed the accelerator and pulled onto Interstate 95. In the car with him were 3 others, 15-year-old Dontavius Butler, a co-suspect named Malik Roberts, and a 4th juvenile female passenger. 4 teenagers, 1 stolen car, and a decision that set everything in motion. On I-95, Morris pushed that Hyundai to dangerous speeds. Other drivers had to react fast. Families in the next lane, commuters trying to get home, all of them suddenly sharing the highway with a vehicle that had no intention of stopping. Police stayed on him. The group exited the interstate and cut into Oakland Park, a residential area. Stop signs went ignored. Red lights meant nothing. These were neighborhood streets, the kind where people walk home and kids play outside after school. None of that registered. They reached a business parking lot in Lauderdale Lakes and abandoned the Hyundai, left it rolling forward in drive with nobody behind the wheel, and ran toward a nearby apartment complex on foot. Here is where the case takes a turn that investigators did not initially expect. 2 of the suspects ran into the complex and hid, but Maurice Thomas and 1 other did not hide. They walked directly through that complex, exited from the other side, and got into a second vehicle that was already sitting there. Parked, waiting. Lauderhill police later confirmed that SUV had been placed at that location before the chase ever began. This was not four teenagers improvising under pressure. Someone had planned this in advance. Police pursued the second vehicle. Both suspects were taken into custody near Northwest 24th Court and 47th Avenue in Lauderhill. The two who had been hiding inside the complex were found shortly after when officers established a perimeter. All four were in custody by the end of that day. Charges included burglary, grand theft auto, and fleeing and eluding police, offenses spanning Broward, Palm Beach, and Martin counties. Not one of them showed any sign of regret at arrest. Subscribe to Crime Teen right now, because what happened in that courtroom the very next morning is something you need to see to believe. The following morning, March 1st, 2016, Maurice Thomas and Dontavius Butler appeared before a judge at Broward County Juvenile Court. WSVN channel. 7 News had cameras inside. The footage captured that day still circulates. When the judge ordered Maurice Thomas to serve 21 days in juvenile detention, his body language shifted immediately. He was not prepared for accountability to arrive that quickly. Dontavius Butler responded differently. He turned toward the cameras and flashed 2 rows of gold teeth. In a courtroom, facing serious criminal charges. The gallery behind them took it further. A young woman in the supporter section began dancing, in the middle of proceedings, right after the detention order was read aloud. Another person in that gallery directed a string of profanity at a court guard, loud enough for the entire room to hear. At the defense table, Maurice and Butler were kicking it with their feet, turning around to acknowledge their supporters. The judge issued warnings. Each one was ignored. The warnings came again, firmer. Nothing changed. The judge reached a decision. Officers cleared the gallery. 6 supporters were removed in handcuffs, charged with contempt of court, and sentenced to 2 days in jail. 2 juvenile supporters were ordered into juvenile detention for 5 days. The room went quiet. No crowd, no energy, no gallery left to perform for. And Maurice Thomas and Dontavius Butler sat still in that emptied courtroom and for the first time looked exactly like what they were. 2 15-year-olds sitting before a judge who had completely run out of patience. Detention confirmed. 21 days for Maurice Thomas. Dontavius Butler held pending further hearings. No reductions, no leniency extended. If you were the judge in that courtroom that morning, what would you have done at that point? Drop your answer in the comments. I read every single one. That courtroom should have been a reset. The record says otherwise. By August 2017, Maurice Thomas and Dontavius Butler were both charged as part of a multi-state crime spree involving vehicle thefts across state lines. That same year, Maurice Thomas was separately named as a person of interest in a homicide investigation out of Fort Lauderdale. In 2019, Maurice Thomas was arrested in Margate, Florida on a robbery charge. He served 542 days in jail. In October 2025, the Florida Department of Law Enforcement and the Broward Sheriff's Office arrested Maurice Thomas again, this time for possession of a firearm as a convicted felon. 9 years, 3 separate cases. The message from that 2016 courtroom did not land. Maurice Thomas and Dontavius Butler made dangerous choices at 15. The record shows they kept making them. What comes next is a different category entirely. The man at the center of this next case did not run from police. He did not act out at an arraignment. He sat in courtrooms for years, calm, composed, and completely certain that the gaps in the evidence would keep him out of a prison cell. He studied the case against him. He watched. He calculated. And for a long time it appeared he might be right. But before the system finally caught up with him, 2 teenage boys paid the price for what he believed he could walk away from. One of them was 14 years old. The other was 16. They trusted this man because they looked up to him. They had been around him before.
This is the 911 call from a woman who discovered a horrific sight.
Those are kids. Those are kids. Huh? No, they're kids. And it hasn't been that long.
Through the wooded area of abandoned homes in the 400 block of River Park in West Louisville, we see the horrifying images of two bodies.
Because there's some shoe prints right here, too. There's some good shoe prints, too.
Your view, LMPD responding officers' body cameras. This is where 14-year-old Larry Ordway and 16-year-old Maurice Gordon's bodies were found. We've learned they were stabbed, tortured, burned, and dumped here back in May.
I need a lawyer, man, if you're going to keep all in my face. I need a lawyer. I don't want to say it.
City's calendar. 3 people were killed within 18 days of each other. A community that was celebrating suddenly found itself demanding answers. Investigators identified a suspect relatively quickly. Building a case strong enough to take to trial took 7 years. The suspect was Brice Rhodes, 25 years old at the time, known around Louisville by the name Rambo. He was an amateur rapper with a presence on YouTube, music videos that referenced drug dealing and street violence. His video titles included Body Armor and Trappin' and Juggin'. That was the image he projected. That was the world he moved in. But behind that image was a criminal record that started long before 2016. In 2009, Rhodes was arrested in Jeffersonville, Indiana for armed robbery. He pointed a gun at a victim, demanded cash and a cell phone. He was sentenced to 6 years and served approximately 18 months. That conviction also involved criminal confinement of a minor, which resulted in Rhodes being placed on the Indiana Sex Offender Registry, a fact confirmed publicly by Clark County Prosecutor Jeremy Mole. Back in Louisville, Rhodes picked up 2 domestic violence charges, one in 2013 and another in 2014. At the time the events of May 2016 unfolded, he was on active probation for those convictions. His stepmother, Anna James, later testified in court that Rhodes had struggled with learning difficulties throughout his life and was never properly evaluated or given the support he needed. She noted that his brother had gone on to become a college professor. Defense attorneys acknowledged that Rhodes' upbringing included abuse and trauma. That is the full documented picture of who Brice Rhodes was before any of this began. Now, the victims. Larry Ordway was 16 years old. He lived with his family in the Beachmont neighborhood of Louisville. He was an honor roll student. Straight A's. He played football. His mother, Elizabeth Marie Wren, described him as a great kid who never took anything from anyone. His cousin, Alyssa Long, who was 11 years old at the time, remembered playing games with him at their uncle's house not long before he was killed. Larry Ordway had plans. He had a future mapped out in front of him. Maurice Gordon was 14 years old, Larry's younger brother. He went by Reese. He loved music more than almost anything. He wanted to rap. He wanted to be in music videos. Family friend Jasmine Smith put it simply. Larry wanted to be a football player, and Reese wanted to be a rapper. That dream is what pulled both brothers toward Brice Rhodes. Rhodes drove them around. He bought them food and clothes. He put them in at least one of his YouTube music videos, something their mother, Elizabeth Marie Wren, told WDRB she had absolutely no knowledge of. To Larry and Reese, Rhodes represented a way into the life they wanted. That trust, built carefully and deliberately over time, is what made everything that followed possible. Christopher Jones was 40 years old, a father of 2. On May 4th, 2016, he was on South 41st Street in Louisville during Derby Week. He had no connection to any of this. He was not the person Rhodes was looking for. He left behind 2 children and a family that would spend the next 7 years waiting for someone to be held accountable. Deborah Wren was the grandmother of Larry and Maurice. She had helped raise both boys alongside their mother. When May 2016 arrived and her grandsons did not come home, Deborah Wren began a wait that would last 7 years, through every court date, every hearing, every delay, every disruption. She was there at the beginning of this legal process. She was there at the end of it. May 4th, 2016. South 41st Street, Louisville, Kentucky. 4 people were in a car together that afternoon. Anjuan Carter was in the front passenger seat. 14-year-old Maurice Gordon was behind the wheel. In the back seat were Brice Rhodes and 16-year-old Larry Ordway. Also connected to the group that day was Jackery Taylor, who had purchased a handgun earlier that same afternoon. Rhodes had identified a man on South 41st Street. He believed that man had a price on his head. He was wrong. The man was Christopher Jones. Rhodes fired. Christopher Jones was struck and transported to University of Louisville Hospital, where he did not survive. He was 40 years old. He had 2 children at home. In the immediate aftermath, Rhodes made a calculated decision. He instructed the group to destroy Anjuan Carter's truck, concerned it may have been captured on camera in the area. The vehicle was burned. The group separated. At that point, law enforcement had no suspects in the Christopher Jones case. No leads, no witnesses coming forward. Investigators were working with very little. That was about to change, but not because of anything detectives found on their own. In the days following the shooting, Rhodes became aware of something through a phone call that Anjuan Carter later testified he overheard. Maurice Gordon had spoken to family members about what he had witnessed on South 41st Street. Rhodes drew one conclusion from that information, that both brothers, Maurice and Larry, would eventually go to police with what they knew. That conclusion is what made May 22, 2016 possible. On the evening of May 21st, Larry Ordway and Maurice Gordon left their home in the Beachmont neighborhood of Louisville. They were going to see Brice Rhodes. They had visited his apartment on Muhammad Ali Boulevard in the Clifton neighborhood before. There was nothing about that evening that gave them any reason for concern. They did not come home. Rhodes had brought both brothers to his apartment, where Anjuan Carter and Jackery Taylor were also present. At some point that night, a confrontation developed. What followed included a vote on what would happen to both Larry and Maurice. Of everyone in that room, Anjuan Carter was the only person who voted against it. Both brothers lost their lives in that apartment. Larry was 16. Maurice was 14. A neighbor named Christopher Jensen had previously loaned Rhodes a black Dodge Charger on more than one occasion. That vehicle was used to transport the brothers to the 400 block of River Park Drive, east of Shawnee Park in West Louisville, at where they were left behind an abandoned home. A fire had been set. Carter and Taylor remained behind at the apartment and cleaned it using bleach. The following day, a passerby came across 2 bodies at River Park Drive. Louisville Metro police officers responded. Body camera footage documented the scene. The condition of the bodies made immediate identification impossible. LMPD. Detective Aaron Tonelli was assigned as the lead investigator on the case. He had no idea it would be 7 years before it went to trial. When Louisville Metro Police arrived at River Park Drive on May 22, 2016, they had 2 victims and no names. Detective Aaron Tonelli and his team began working immediately. The condition of both bodies made the standard identification impossible. LMPD released a public sketch of both individuals and waited for the community to respond. The response came from Olmsted Academy in Louisville. Detectives contacted Elizabeth Marie Wren. She identified her sons. Then she told investigators something that immediately changed the direction of the entire case. She believed the deaths of Larry and Maurice were connected to what they had witnessed on South 41st Street 3 weeks earlier, the shooting that took Christopher Jones. That information opened the Jones investigation for the first time. Until that conversation, law enforcement had no suspects and no meaningful direction in the Jones case. Detective Tonelli moved on Brice Rhodes quickly. He brought him in for a recorded interview. That recording was later played in full for the trial jury. During the interview, Rhodes told Tonelli, "I haven't spoken to Gordon or Ordway in about a week." Detectives then informed Rhodes that they had evidence placing him outside the victim's home on the evening of May 21st, the night before both brothers were found. Rhodes' account shifted. Tonelli documented the shift and did not accept the revised version. He remained on this case for 7 years. The first significant forensic breakthrough came through digital evidence. Cell phone records placed specific individuals at specific locations during the relevant time period. That data identified people directly connected to Rhodes, which pushed the investigation further. This method was later confirmed by LMPD, the Kentucky Attorney General's office, and referenced in Kentucky Supreme Court appeal documents. Physical evidence developed across several searches. The first search of Rhodes' apartment on Muhammad Ali Boulevard produced nothing immediately useful. Defense attorneys would later point to that empty first search as evidence of investigative overreach and tunnel vision. Detectives returned for a second search. This time, they found blood beneath the surface of the carpet. Forensic specialist Stephen Barrett examined the material. The DNA was a match for Larry Ordway. Further evidence was recovered at separate locations. A blanket pulled from a public dumpster was matched to Maurice Gordon. At Rhodes' mother's apartment, searched independently, a crime scene technician recovered 2 knives. Rhodes' blue Mazda was located and examined. The back seat had been removed. The interior carried a noticeable smell of bleach. Blood was present on the driver's seat. Our Rhodes' own DNA was confirmed on the steering wheel. Defense attorneys would later challenge the documentation around the missing back seat, arguing the evidence chain contained gaps that could not be explained. Kentucky State Police forensic expert Jeffrey Scott Doyle testified that he was unable to directly match tire tracks or shoe prints from the scene to Brice Rhodes. That finding anchored the defense's central argument throughout the trial. 3 people present in that apartment on May 22nd eventually accepted plea agreements. Anjuan Carter was 15 years old at the time. In November 2016, he pleaded guilty to 3 counts of facilitation to commit murder and 1 count of tampering with physical evidence. He was sentenced to 10 years in a juvenile facility, then resentenced to adult prison at 18. In July 2019, he was released on 5 years of probation with a 20-year sentence held in reserve if that probation was ever violated. As a specific condition of his release, Carter was required to pay for headstones for Larry Ordway and Maurice Gordon. At the time of the 2023 trial, he was being held in Hamilton County, Florida, on a separate burglary charge. Jackery Lamont Taylor was charged in October 2016. His plea agreement was finalized in 2018, and he received a 10-year sentence. Tyrone Coleman was also charged and resolved his case through a separate guilty plea. Detective Tonelli attended every court appearance over those 7 years without exception. After the verdict in December 2023, he spoke to WDRB and said, "In 18 years of doing this job, I know evil. And that man is evil." From the moment Brice Rhodes entered the court system in 2016, he made clear he had no intention of cooperating with it. In September 2016, Rhodes appeared before Judge Amber Wolf in Jefferson District Court, restrained in a 4-point chair and wearing a protective mask. From that position, he told Judge Wolf he could find out where she lived and threatened her family directly. A terroristic, threatening charge was added to his case that same day. The following month at Metro Corrections, Rhodes threw urine at a correctional officer and attempted to assault a second one. 2 additional charges followed: assault on a correctional officer and intimidating a participant in the legal process. He also attempted to escape custody by trying to dig through a cinder block wall in his cell. His defense attorney, Brendan McLeod, withdrew from the case in 2016 after discovering that the victim's grandmother was a close personal friend. When McLeod tried to explain this, Rhodes spat on him. Later, in open court, Rhodes looked at McLeod and said, "I'll see you when I get out." Over the following years, Rhodes fired or pushed out multiple attorneys. He accused a sitting judge of having a personal relationship with the prosecutor. He called that same judge a secret KKK member. He accused 2 LMPD homicide detectives of fabricating testimony. A court-ordered competency evaluation was conducted by Dr. Timothy Allen of the Kentucky Correctional Psychiatric Center. Dr. Allen confirmed a measured IQ of 71, antisocial personality disorder, anxiety, and substance-related issues, but concluded Rhodes was mentally competent to stand trial. In October 2023, Judge Julie Kalin accepted that finding and confirmed that due to his documented intellectual disability, Rhodes was not eligible for the death penalty. Trial was set for December 11, 2023. Before the first witness was called, Judge Kalin warned Rhodes that any disruption would result in removal or a stun cuff. For the first time in 7 years of proceedings, Rhodes sat quietly through the entire trial. The prosecution was led by Assistant Commonwealth's Attorney Crit Cunningham. He described Rhodes as callous and casual in the Jones shooting and calculating and cruel in what happened to the 2 brothers. 3 co-defendants had already accepted responsibility, and the evidence would confirm Rhodes directed all of it. Defense attorney Wesley Boyarsky argued Anjuan Carter was the real person responsible. No murder weapon was ever recovered. Rhodes' DNA appeared only on his own steering wheel. LMPD, he argued, had tunnel vision, referencing the same department involved in the Breonna Taylor case. Judge Kalin immediately instructed the jury to disregard that comment. Boyarsky told the jury, "I'm here to make sure no one is wrongfully convicted." Anjuan Carter testified in detail. He described the seating positions in the car on May 4th. He described the phone call he overheard. He described the vote on May 22nd and confirmed he was the only person in that room who opposed it. On the stand, he said, "Make sure I get out. Try to save somebody else. Make sure I'm safe." When asked what would have happened if he had not gone along, probably been with him, probably the same situation. Under cross-examination, Carter acknowledged he had lied to police multiple times during the earlier investigation. Anjuan Carter was 15 years old in that apartment. He carried what he knew for 7 years. In December 2023, he chose to tell the truth when staying silent would have been easier. That decision brought this case to a verdict. Jackery Taylor had to be threatened with contempt before he agreed to take the stand. Once there, he confirmed Rhodes was the instigator and that Rhodes directed what happened. He told the jury he had never done anything like this before. At one point, he broke down and said, "I couldn't do nothing, though. I was scared. We were all scared. I just know we really couldn't save them." Detective Tonelli testified about the full investigation. The jury watched the recorded interview where Rhodes claimed he had not spoken to the brothers in a week, while evidence already placed him outside their home the night before they were found. Forensic specialist Stephen Barrett confirmed the DNA found beneath the carpet in Rhodes' apartment matched Larry Ordway. The medical examiner testified that Christopher Jones died from a gunshot wound that struck his liver at University of Louisville Hospital. and that Larry Ordway and Maurice Gordon each died from multiple stab wounds. Kentucky State Police forensic expert Jeffrey Scott Doyle testified he could not match tire tracks or shoe prints to Rhodes. LMPD technician Jesse Huffman confirmed blood on the driver's seat of the blue Mazda. The defense challenged the missing backseat documentation through both Huffman and Sergeant Jason Vance. Neighbor Christopher Jensen confirmed he loaned Rhodes his black Dodge Charger on more than one occasion. The defense moved for a directed verdict at the close of the prosecution's case. Judge Kalin denied it. In her closing, ACA Elizabeth Jones Brown told the jury, "I don't think the family of those brothers should ever have to go to sleep again without knowing where Brice Rhodes is." She reminded them of his prior convictions for assault, burglary, and robbery. Deliberations began December 18, 2023, at approximately 5:45 p.m. The jury returned at 9:30 p.m., under 4 hours. Guilty on all counts, 3 counts of murder, 1 count of tampering with physical evidence, 2 counts of abuse of a corpse. The penalty phase jury deliberated under 1 hour and recommended life without parole. Sentencing was held March 13, 2024. Defense attorney Thysa Hayworth told the court, "No matter what he did on his worst days, Brice is still a human being." She cited his childhood, bipolar disorder, and intellectual disability. Rhodes's stepmother, Anna James, testified he had struggled with learning difficulties his entire life and never received proper support. When informed of his right to appeal, Rhodes gave a quiet thumbs up. He said nothing else. Sean Jones, Christopher's brother, addressed the court about years spent without answers. Chastity Stoner, mother of Christopher Jones's son, told the court she wanted to focus not on what Rhodes caused, but on what he failed to destroy. Her son became a 4.0 GPA student and received a football scholarship offer from the University of Louisville. Deborah Wren stood before the court and said her grandsons would now be grown men living their own lives. They never got there. Rhodes never showed remorse, not once in 7 years. She said, "I just hope that when he goes to prison that he gets down on his hands and knees and asks God to forgive him." Judge Kalin delivered the sentence. She said, "This has been by far one of the most tragic cases I've ever been involved in. Everything about this case is horrific." She stated it would be dishonorable to deviate from the jury's recommendation. 3 life sentences without parole, 5 years for tampering with physical evidence, 1 year each on 2 counts of abuse of a corpse. Per Kentucky law, the 2 life sentences for the brothers ran concurrently. Defense attorney Tom Griffiths filed notice of appeal at the conclusion of sentencing. ACA Elizabeth Jones Brown said afterward, "Justice to Christopher, Maurice, and Larry. It was a good feeling to be able to bring, here is something almost no one covering this case has told you yet." At the conclusion of sentencing in March 2024, defense attorney Tom Griffiths filed a formal notice of appeal. Multiple arguments were raised, challenging both the conviction and the sentence handed down by Judge Kalin. On February 19, 2026, less than 6 weeks ago, the Kentucky Supreme Court issued its ruling. It was unanimous. Every argument the defense raised was found to be without merit. Every conviction was upheld. Every sentence was upheld. Brice Rhodes remains in prison for the rest of his life. No possibility of parole. Ever. Attorney General Russell Coleman responded with a public statement. He said, "Justice has once again been affirmed. With the appeal denied of this 3-time convicted murderer, the court has reinforced that accountability does not expire." Commonwealth's attorney Jarena Weathers added, "Nothing can bring back the 3 precious lives this defendant took. Our hope is that the families of these victims can rest easier, knowing that his lifetime sentence has been confirmed." The system that Brice Rhodes spent 7 years attempting to manipulate had the final word. It said no, unanimously, 2 courtrooms, one theme running through both of them. In Broward County, 4 teenagers treated the legal process like it carried no real authority. In Louisville, a man spent 7 years in courtrooms doing exactly the same thing. What changed both outcomes was not what the defendants chose to do. It was what other people around them decided. A judge who cleared a gallery when warnings stopped working. A 15-year-old who carried the truth for 7 years and eventually chose to put it down on a witness stand. Anjuan Carter was 15 years old in that apartment. He waited 7 years before he testified. Knowing what it would cost him, would you have done the same? Drop your honest answer in the comments below. Share this video for Larry Ordway, Maurice Gordon, and Christopher Jones. They were 16, 14, and 40 years old. One share means one more person knows their names. That matters. Subscribe to Redacted Files. Every case on this channel is fully researched and accurately told, including the February 2026 update that most channels covering this story have not reported yet. Hit subscribe and turn on notifications, because the next case involves another choice, made by someone who had no idea how it would end. You will not want to come to that one late.